Greetings and welcome. As human beings, we all have ideas. The origin of those ideas, whether they be from intelligence or from a higher divine power, we may differ on where the ideas originate from. But one thing we do know is that we all have ideas. We may not all know how to create value from those ideas or earn or expand or evolve those ideas. Essentially, we don't know how to empower those ideas. This is where we welcome you to Ideas Empowered. I'm Hans Devines, your host for today. Ideas Empowered, a masterclass on identifying, protecting, valuing, and earning from your creative assets in our evolving creative economy, where it's becoming more and more important day by day in front of our eyes, and where we can hear it's becoming more and more prevalent. We want to say thank you to our partners, Trinidad and Tobago Intellectual Property Office, ModCom, Quantum Business Solutions, and Carnicon. Now today, it will be divided into 4 sessions, and we want you to share the information with your friends, share the links via social media, or even the meeting link. So the 4 sessions today will consist of Session 1, a masterclass on intellectual property. Session 2, demystifying NFTs, the digital future of creative expression. Session 3, identifying, quantifying, and monitoring value in the creative economy. And Session 4, well, you know, in Trinidad and Tobago, we love FETs. FET of the minds, the role of intellectual property in the carnival industry. So without wasting any time, let's get straight into it. Our first session, our panelists include Dr. Andres Gudamus, lecturer of intellectual property law at the University of Sussex and the editor-in-chief of the Journal of World Intellectual Property. His main research areas are artificial intelligence and copyright, open licensing, cryptocurrencies, and smart contracts. He has acted as an international consultant for the World Intellectual Property Organization and has done activist work with Creative Commons. Next up, we have Regan Asgarali, controller of the Trinidad and Tobago Intellectual Property Office. We also have Richard Atching, manager at Technical Examinations, TTIPO. Kavish Seetahal, Deputy Controller of the TNT Intellectual Property Office, and this session will be moderated by Khalil Mohammed, Business Development Consultant and Intellectual Property Specialist. We want to remind you all, during the sessions, you can direct your questions in the question and answer box to the right of the screen. We welcome you to Ideas Empowered, a masterclass on identifying, protecting, valuing, and earning from your creative assets in our evolving creative economy. Khalil, over to you.
Thanks. So today this event will be a first of its kind. The event will show the value of intellectual property, not only as protection, but as a very rare but precious asset or creative and innovative professionals that will therefore help the economy. In our first segment today, we have Dr. Andreas Gudamus from the University of Sussex, who is an expert in copyright, AI, and all other forms of IP. Dr. Gudamus will take intellectual property from just knowing it as a form of protection to showing it as something that is around us every day, without us even recognizing. To further this discussion on the intellectual property as it relates to business perspectives, the protection or the way how to secure income and inventions for various creators and innovators, I'd like to introduce our featured speaker, who will take a deep dive into intellectual property as the key ingredient to creation innovation. And as we know, Dr. Gudamus is an international consultant for WIPO and has introduced the senior lecturer at the University of Sussex. I'd like to hand over to Andreas Goodemos.
Thanks. Let's see. Thank you very much for the very kind introduction. I'm going to share my screen. It worked earlier, so hopefully it's going to work now. First things first. Sorry, you're going to see something. All right. Can you see the screen? I'm going to try to put the chat as well. Excellent. Thanks very much, first of all, for the very kind invitation. I am absolutely honored to be here with you, even if it is virtually. I have to start with a bit of an apology. I always like to start my presentations with an apology, but today the apology is probably more needed. I unfortunately tested positive for COVID on Saturday. So my voice is going to be a little bit weak. I'm feeling fine. It's evidence that the vaccines work. Sorry to make that point. I've only had a mild cold, but I am a little bit under the weather. So I apologize for that in advance. Even though I'm feeling quite well. The other part of the apology is that this first part of the presentation is going to be very general. There's no nice way of saying this, but because in general, in the sense that I want to set the stage of what intellectual property and what is important about intellectual property. Hopefully, we'll manage to do that in a short time. Why? While I want to do it this briefly, because for the second part, whenever we're going to go into the second panel talking about NFTs, I'm going to run out of time. And there is no way I'm going to manage to do NFTs in the allocated time, but hopefully we'll manage both. So this is going to be more of a general introduction and about the understanding of what we mean by intellectual property. By the way, I've put the Wordle image on purpose. Wordle is a very interesting case example of a story of a success, global success. I don't know if anyone else is as obsessed with Wordle as me. I've been obsessed. Today I got a score of 2, which I'm very proud of. But the interesting thing is that the person that generated or created the game did not protect any of the intellectual property. So the Wordle name is already been used by other people. There is not a trademark. And it's someone that has created a runaway success without actually even thinking or maybe thinking ahead that there was going to be such a success. And now probably eventually there will be a monetization because everyone has very good will towards this person, but it's almost not protected by any type of intellectual property. There is no trademark, there is no, and anyone can create their own versions. So interesting example. So I just wanted to start with that. As I was saying, I'm going to have a very broad introduction to what is intellectual property. And obviously, from the name, we are talking about the property of intellectual creations, as the name implies. This means that what we're protecting, we are protecting things that are the creations of the mind: literature, art, music, but also inventions, innovations, reputation of brands, the innovation that goes into a design. All of these things are going to be protected or fall under the umbrella of intellectual property. And that is one of the powers that it has. Of course, there are different types of intellectual property, and in the next presentations, you're going to hear more about the different types, but just to set the stage for now. There are very different types of intellectual property. We have the 3 main ones generally that are understood as copyright, patents, and trademarks, but then we have designs, also known as design patents in some jurisdictions, or industrial designs in others. Also, things like confidential information and trade secrets that are where companies are going to try to keep some of their know-how secret by not disseminating it. You can also have protection of things that you have not disclosed. You can have things like plant varieties, geographical indications, and even databases. And of course, with each one of these things, each one of the types of intellectual property, you're trying to achieve something. So to give you an idea, what you're trying is to promote the arts, then you are going to use copyright. If you want to reward investments, you are going to use patents. If you want to protect your reputation or brand reputation, you're going to use trademarks. And if what you want is to protect the distinctiveness or something that is distinctive, then you're going to use designs. And if you want to use, for example, the protection of a region's produce, like champagne or cheese or milk or some wines, some types of coffee, then you use something that is known as geographical indications. Now, all of these are very general, of course. We're going to see them in more detail later. Now, obviously, all these types of intellectual property have different, because they are trying to achieve different objectives, they are all going to have different types of protection. So there is difference in the type of rights that you are given. There is a difference in the strength of the rights. Patents are much stronger but shorter because they act as a monopoly. You're protecting inventions. Trademarks last for as long as you have a reputation. There are trademarks that are over 100 years old because they're from companies that still have a reputation. And then you have things that copyright that are protected by lifetime of the author plus 70, 50 years, depending on the jurisdiction. So you have all of these different types of protection that are going to be strong in different ways because they're going to try to achieve different means. But generally, the reason why we have intellectual property is, well, obviously there are various reasons. One of them is perhaps one of the better known is that we are trying to incentivize creativity. We want people to share their ideas. And one of the ways in which we can do that is by giving people some form of rights. And then we can also have a reward for those who create new things. I create something, a society wants to reward this person for what they have created. We want to encourage, but also we want to reward, to reward those people. It also acts in many ways as a social contract. The social contract that society has, particularly with inventors, but in general with intellectual property creators, is that society will give this author or inventor a property right, usually an exclusive right and sometimes a monopoly right, in exchange for them sharing their work. And this is a very important part of the social contract. We want to encourage innovation, but we also want, this is very important, we want to take part, we want society to take part of those things whenever they run out of patents or copyright. So we are, particularly, I'm going to concentrate a little bit on the creative industries as an example of how intellectual property can encourage this type of innovation and creativity, specifically in the creative industries. It is, however, intellectual property is embedded in all of the industries. It's embedded in the pharmaceutical industry, is embedded in many other types of industries, but particularly with the creative industries is a very big importance. This is going to be part of what we're going to talk later when we're going to deal with things like NFTs. One of the things that I want to stress, perhaps, is that technology informs legal change, particularly with copyright. Technology is a driving vehicle for copyright reform. new types of works are going to be added to subject matter all the time. So, for example, when copyright was created back in the 18th century, it was created as a response to the printing press. Of course, the printing press predates that for a few years, but now we have a publishing industry. Now, what we have then is that the law needs to respond to this and create a system that encourages that dissemination of information. So first we have that. For many years, it was only about printing. Then we have start to see new innovations in technologies that we now consider a little bit trite or a little bit basic, but imagine a world in you have the first things like pianolas where people can actually make music and make copies of music. It may have seemed like magic for some people. Then we start seeing photography, then phonograms, then film, radio and television, and cable. And every time that the technology is going to change, the law, particularly intellectual property, but specifically copyright, has to respond to those changes. So we're going to start seeing the law saying, okay, we have this new technology, we have pianolas, we can reproduce music. We have phonograms. We can now reproduce music in really impressive ways. We need ways of protection or ensuring that protection to ensure the reward that we want to give to the innovators and to the creators. And the same thing happens with all of the technologies that we have had to make those changes. All right. So technology brings forward change in the law. Everything, however, changes with the creation of the internet. What do I mean by that? Before, things like certain types of intellectual property, particularly things like copyright, were actually sort of niche systems, niche ideas, in which we are going to have for example, to create a copy of something. For those of you who are older, you will remember that to copy music, it was very difficult. You had tape. If you're of a certain generation, you'll remember listening to the radio with a tape recorder trying to listen to a song. So copying was difficult. Analog copying was imperfect. Even photocopies to photocopy a book was imperfect. If you had a bad photocopier, you would not be able to create a good copy. So the only barriers are technological, internet speed, storage space, device capacity. But now things can be copied perfectly. So that is going to be one big change. Everyone nowadays can be an author, a publisher, a distributor, and a producer. So the barrier to entry into the creative industries, particularly, is going to be much smaller in many ways. I'm talking specifically about copyright industries and creative industries. So what we're going to talk about mostly in the later parts is about the future of creativity. What the history is over, and what we have now is a very bright future that we are seeing a monumental change in the creative industries, but also in other industries. We start seeing innovation in artificial intelligence, in patents, but in the creative industries, we start seeing the rise of user-generated content in which nowadays things like Twitch, things like social media, TikTok, and even other types of social media, like things like YouTube, Instagram, are creating a new wave of creators that do not rely on the same intermediaries as before. They have a more direct path towards the users and the market. So that is a very, very, very big change that we have to start thinking about from a regulatory perspective. So then we have the rise of esports. And that sometimes some types of esports go, the price in things like Dota 2 tournaments is higher than most tennis tournaments, to give you an idea. Then we start having the rise of artificial intelligence in the creative industries, where we see more and more things that are going to be generated with a machine. And this is another very big topic. Then we start having the rise of what is now understood as the metaverse. I am a bit skeptical about this because I think that the metaverse has been in existence for a long time. We used to call them virtual worlds or gaming. Some things like Second Life have been around for a long time. So it depends on your definition that is going to be met. Then we have the rise of blockchain NFTs, what is sometimes called the Web3 revolution. We're going to talk about that in the second panel in more detail. So I wanted to finish with a couple of ideas of how intellectual property can help, particularly thinking about all of these technological changes. So I've told you that all these changes, all of these technological changes are probably going to have to prompt a change in the law, or at least a regulatory response. So how does intellectual property keep pace with all of these changes, all of these blockchains and NFTs and artificial intelligence and all these things that are happening? How is it possible that we can keep track of all these changes? So I like this phrase that I've heard before: regulators are archaeologists, not detectives. I wish this was my phrase. It's not. I have no idea who said it, but it's very true. Regulators are very bad at proactive changes. So we have to see what's happening to respond. And so maybe there's no need to change the law just yet. Just use whatever is already here. So to give you an idea, there was a very early case dealing with the internet back in 1996. There were a few other cases, but this is probably one of the first historical cases. This is a Scottish case that dealt with the internet when we didn't have a lot of definitions. There were not a lot of technical definitions. There were not a lot of, well, lots of technical definitions, but not legal definitions. And the Court of Session had to ask a very obscure case involving copyright infringement of headlines. Containment, hyperlinks is not important. What was interesting was that because the internet had not been defined, had a legal definition, there was a bit of a danger that judges would just go and say, okay, what are we going to do? How are we going to manage with this new technology? The solution was very interesting. Lord Hamilton smartly declared that the internet was a cable program service. So for a few years, the internet was a cable program. It's a fascinating, fantastic solution. Now, you may be wondering, why am I using this? Because this has been repeated all the time. Sometimes we have lots of new developments, not only technological, but sometimes societal changes that require new approaches from intellectual property. So we're going to have computer games, dances, performances, folklore, traditional expressions. All of these can be technological, but also societal, that are going to require a change in the law or new approaches on how to think about intellectual property protection. And this is where I want to finish with this thought that is going to be explored later as well. For example, how can you protect a nation's creativity? Are there already tools? Well, there is no such thing, for example, as a protection of carnival. There is no copyright on carnivals or on traditional expressions. But maybe we can start looking, taking a page from the book of technological change to see how we can look at protection of intellectual property, of all of this creativity that is out there, and we can use all of these tools for protection. So maybe things like performers' rights, passing off, which is a tort in many common law systems. Maybe use designs, trademarks, Push for very traditional knowledge and folklore international protection. That is something that the country can do. Things like unjustified enrichment and maybe even the use of contracts. I am a big believer on contracts. When in doubt, you can release a contract. So with that very, very broad introduction to the subject, I give back the word to you, and I'll be delighted to talk about NFTs a little bit later. Thanks very much.
Hi, Dr. Gudmus. Thanks for a very powerful presentation. I'd like to start because you mentioned something that to me is very relevant, and addressing would do a lot of good protecting the IP rights of many. As you stated, with time advancing and technology advancing, some of the former IP protocols that may have been out there would be effective, but not as effective. What solutions or what game plan do you think should be put in place given that with the advent of the blockchain, NFTs, and other forms of new age IP? What do you think could be put in place to protect the inventor?
Excellent question. I think that for the most part, I think we already have a lot of tools to protect creators. The first thing that you have to do, and one of the reasons why I mentioned Wordle was you have to think ahead. So you have to look at what is available now. It's very important, I think, that you don't go to a new space thinking that the law is going to change to fit your needs. And that almost never happens. Let's be honest, the first internet pioneers didn't go saying, okay, at some point, someone is going to change the law, and this is going to benefit me. They started building tools, they started building things, and then the regulators managed to respond eventually. So I think that right now, look at the tools that are already in existence. I'll mention that when we talk about specifically about NFTs, but with things like blockchain, I think that most of the tools are already there. I don't think that we need a big change in the law. Already in things like smart contracts, the Law Society of England and Wales has already declared that the legislation in place is already strong enough to accept the deployment of smart contracts and things like electronic signatures, cryptographic signatures, and things like that. So my first recommendation is try to use things that already exist. That is going to be the first one. When in doubt, terms of use, a very well crafted terms and conditions can go a long way and bind people with a contract. And intellectual property can help as well.
Understood. That's great. And actually, I think as well, given that culture and creativity transitioned a couple of years ago, and they used, as you said, what was already there to seek protection, I think technology could then follow the same path that they would have followed. Because as I said, using what's there is also simplistic, and it also follows legal and best practice in terms and conditions, in terms of use rate as well. It's funny that you mentioned that, because in our next segment, we have Mr. Regan Asgarali from the IPO, the controller, presenting on franchising and basically using those tools and IP to foster growth, not only for your business, but in also other practices, whether it be product development or whether it be in, taking your business from a local business to international business. So what I'll do, I'd like to hand over to our host. And yeah, we look forward to a very powerful segment, and also thanks again for your contribution.
Thank you, Khalil. And thank you, Dr. Guadamuz. I think, I would love to be on the same cricket team with you, Andres, because certainly we're batting from the same position, the tools to maximize intellectual property. So to go into it, I'm going to share screen, some slides I've created, but it's all about the tools. Trinidad and Tobago and a lot of countries in our region. Firstly, welcome to our national and regional community here following this. But Trinidad and Tobago and a lot of the countries have put in place a lot of legislation. So a lot of legislative tools. In fact, in the last year and a half, we've acceded to the Rome Convention, the Madrid Protocol, the Beijing Treaty, the Marrakesh Treaty, and others. And also we've developed more tools to help creators and innovators, the SME class, etc., to maximize their benefits from IP rights. So the important thing here really is to look at the tools of licensing, franchising, merchandising, to uplift your IP, to ring fence it, and then commercialize it. And then after that, what are the support services that the regulators like ourselves have working with WIPO and the Academy, one of the main partners for this, together with others here today, the very important Conacon and Quantum Business Solutions, to help you to maximize your returns. One of the important new advances is the National IP Training Center. And I was thank the host for the time to allow us to introduce it. It is one of just 12 centers in the world and the second in the Caribbean after Dominican Republic. And it will be a very important tool, teaching tool with over 28 trainers, 10 from the IP office and over 12 from the private sector, some from the universities who underwent 2 years of training. And you would have seen our release on the National IP Training Center. So the expertise that we're building through this IP Training Center will result in certain courses across the line, including new and emerging areas that Dr. Gudamu spoke about, such as today's session, to help us to uplift and grow the IP sector in Trinidad and Tobago. So this is a slide from some of the training that was opened by Professor Brian Copeland, and Joe Bradley is on screen from the World Intellectual Property Office. Intellectual property, as Andres went in, refers to the expressed creations of the mind. This is one of our staff's creations, and is currently the mascot of the IPO. And I put on screen the types of IP so you would see. So today we are focusing on the branding, the inventions, some bits of industrial design, which protects the ornamental aspect, the branding, protecting your corporate name, etc. And looking at how you can maximize that besides copyright and neighboring rights, which protects original literary, dramatic, and artistic works. So what does intellectual property do? Well, it gives you very important types of rights. The economic rights, we like to call it the rights of communication, adaptation, reproduction, and distribution of your work. And also the right to be recognized as the creator of that work, which is the moral rights. And what I am focusing on, it would be the transferring, the licensing, the saying how economic rights can be exploited. My colleagues in 10 minutes will focus on the types of IP rights. So these rights, as I've said, you can sell your IP, you can license it, including your creative products, which is the purpose of today's sessions, by way of franchising and merchandising, joint ventures. Andrew spoke about contracts. Contracts are critical. One of your best weapons in IP exploitation is to have an intellectual property lawyer at your side to go through and navigate all of these pitfalls, because IP is a rabbit hole. There's so many different types of intellectual property. So knowing and being advised on the best types for your particular situation is critical. And if you get this right, then you will improve your revenue. In fact, you will improve competitive advantage. I remember 20 years ago as a young lawyer, everybody wanted to have the BlackBerry phone, right? That was in style at the time. Then, of course, Steve Jobs came with the iPhone. And so really the purpose of IP, probably protecting the IP, is also to move with the times. So the discussion earlier about the laws catching up to the new areas, I was happy to hear about the perspective that we do have laws. Definitely there are things in place, contracts and other things that are very important to help you fully exploit the IP assets to extend your brand and image. A great example was Mario Sabga, when he was trying to come up with his brand of coffee for his store. It was said that coffee wasn't popular in the Caribbean. And he went to his wife, like many of us, for inspiration, and she asked him, well, what does coffee mean to you? And he said, it's my ritual. As simple as that, a great brand was born, and it's been exploited, and IP exploitation is a good thing. It's been licensed, and the rituals is all over Trinidad and Tobago and the Caribbean. And why is this so important? Because of the link to the orange economy. Regulators, policyholders are giving more attention to the orange economy, core in advancing the cultural and creative goods and services, and performing games, gaming, fashion, music, etc. This is contributing to the growth of the IP economy. 34.8% of the creative entrepreneurs in Latin America from the Orange Economy study have indicated here that they pursue their intellectual property, saying it's expensive or they do not know the procedure. This is an important part. We as regulators, we as policyholders have to demystify intellectual property. And the IP office has done a lot of that. All our services are now online, as my colleagues will talk about, and also all our tools online and available. So the importance for the region is to try to look at this and see how intellectual property can be made more user-friendly for the important persons who have to use, creators, the SMEs, etc. When you look at the last data that we had on IP and the orange economy, on our contributions of copyright-based industries, the contribution to Trinidad and Tobago's economy was around 4.8%. At the time, I think it was about $7 billion. Unemployment at 5%. Even with the pandemic, where there have been issues with performance rights, etc., we are a very resilient region, and we're going to come out of the pandemic and be very stronger. And these are the sectors that, as policymakers, we are going to have to put emphasis on. From Dr. Vaness's James study that I've put on this, you could see that in 2000, copyright contributed approximately 1.998 billion to the economy, as much as 3 times as the agricultural sector, 626 million, and 2.8 times just the hotel and guest houses sector. So it is growing, it's very resilient, and it's something that we really have to put emphasis on. So in terms of the tools, as I'm focusing on certain types of rights, I've just pulled a couple of rights to deal with inventions, novelty. To get a patent, it's the exclusive right granted by the state to an individual for his or her invention. It must be not easily reproduced, and it must must work, right? So what are the potential aspects in relation to the carnival industry? Taken from the IPO's handbook, I just leave some of these here to look. The steel pan evolution, new types of pan. Let's explore that. These are 2 types of steel pans. 5-pan, the percussive harmonic instrument that was invented by the team at UE, led more than a decade in taking this. Keith Menard, Professor Copeland, Earl Phillips, Russell Byron. And what is it? It's akin to an electronic synthesizer with a circular shape to lend more versatility when compared with the linear structure of the conventional synthesizer. We are looking forward to the licensing of this and exploitation of its use in different markets as the patent still has life. And very importantly, the Genesis pan that is owned by Corporation Soul, and a plan for the remainder of the years with the Genesis pan of the patent for it to be properly licensed in different markets. And if it's done, and this is what some of these topics then you can see royalties coming back to Trinidad and Tobago, foreign direct investment, etc. This is what it's about. Similarly, merchandising in Carnival. I'm just borrowing here from the Samba schools in Rio's Carnival. As you can see on the screen here, they have licensed tremendous merchandise for their Carnival logos, as you can see with Tijuca. And the Samba schools perform at the Samba Drome, which is also ring-fenced as Rio's Carnival is, in terms of broadcasting rights and these things. So the merchandising underpinning it is trademarks, designs, artwork, all of these things. And then, of course, it's backed up television rights, film. You have it on toys. You imagine a Peter Minshall's work on a bed sheet, on a lunch kit, how you start now to indicate pride in our culture through merchandising. And what merchandising does, engaging brand visibility. It's a value marketing tool. There's market expression. It's relatively risk-free and a further revenue stream through royalties, etc. So these are some of the benefits here of merchandising on the screen for you. And, it's something definitely to be encouraged. I saw at the water park in Chagaramas, they're trying to bring some elements of folklore back into branding, such as the Papa War area, water slide, etc. So making us change our mindset to see our beautiful folklore, our brands, etc., being licensed out into the world is a very important part of what we're trying to achieve here as a country. And as you can see, I've broken down the type of important areas as a lawyer in a merchandising agreement. And you would see it there from one of our WIP partners who presented on it out of Singapore. Another important area is, of course, for creators, SMEs, etc. So know the difference in these licensing agreements between licensing and assignment. Assignment is almost as if you sell your house. If I sell my house, I can't go back there next week and enter. The new owner could throw me out. So assignments are basically is all of the rights being given to the new owner of it. And therefore, you can freely change, adapt, and dispose, you can reassign and license, etc. Whereas think of a license as more as if you rent your house. You would still have rights to go in there under certain circumstances, right? So these are the important distinctions that one must know in terms of licensing and assignments. So going into it, a license is a contract for exclusive rights to use IP. It may or may not comprise exclusivity. And I've put here the types of licensing in the creative sector. For instance, a mechanical license grants the right to reproduce and distribute a specific composition at an agreed fee. A synchronization license, when I think synchronization, I'm thinking Naveed, my good friend, I hope he's on, who is the fantastic score for the Ansa Makal Awards, the Nobel laureates. That score carried that and really brought it alive, Naveed, I must say. So the license for that, syncing, through synchronization, commonly used by music publishers who issue licenses or copyright owners. Usually a producer grant right to synchronize the musical composition. Then there are broadcasting and online licenses that grant permission to use a portion of the radio frequency spectrum given in a geographical area. And of course, a business arrangement is one in which a company gives another company permission to manufacture its product for a specified payment. These are some of the licensing issues to note as we touch very briefly in the time that I have. They're all on screen. I've put it here, plus clickable links for you in terms of the importance of licensing issues. Identify the parties, decide on assignability of license and sub-licensing. Identify the product covered by the license of the type of IP and the deliverables, and determine the payment, whether it's one-off royalties that could come back. I gave the example of the Genesis plan that could potentially generate royalties for the country, etc. Determine the territories covered by the license and determine the term of the license. These are all very important parts. points. In 2014, we spoke about this at Carnival and IPNCC, in which Regan, who have quoted from here, appeared alongside Richard Atching and myself to go into these rabbit hole of licensing. And with some of the clauses that you looked at. Various clauses that are very important. How to really maximize your brand. That trademark, whether it's tribe, whether it's army. I remember being involved in the beginning of that, Mr. Sobian, and to see where it has flourished now is really amazing, where they're taking that the world. So, intellectual provides licensing benefits. I am a fan of licensing. It gives you the ability to enter into all fields, as well as your products into different geographic markets. And one of the important support services I will talk about to enable this will be the Madrid Protocol. Going back here, licensor creates a potential, could create a potential competitor. These are some of the risks. And then, of course, I'm looking at the risks from the licensee. But a very good, well-constructed license can navigate through the waters and see you to more of the benefits of it. Even in terms of broadcasting on the film side, you know, there are different types of licenses, set designs, musical, film, etc. Yes. So as I close in 5 minutes, I just wanted to go through and show you it's important for film. Look at your clearances for your property. You can't just go and film something for Carnival or on the road. You have to get permissions. You have to even look at bringing equipment in to make sure you liaise with customs, to make sure the stock and these things are clear, right? And of course, the locations, very important for that. You know, even in photography, you have to make sure that you protect your photographs very carefully. There's the poor man's copyright. You can register post back to yourself. You now can use your phone as records. This is a very important case. The NATU's counsel on it between Sean Drakes and his photograph was improperly used or communicated to the public. And he was able to succeed in this case and of the illegal reproduction of the photograph. So you're using the law, you're using the tools, you're using agreements. As you see, it's all here in the slide of different templates that I have provided for the viewing public to really give you that competitive advantage. And what's the end result? The end result could be something like Caroline Mackenzie's Netflix deal. It's all about licensing here and deals, where her book may be exploited on film by Netflix. There's an agreement that will allow it to be produced, and also there are different publishing rights, etc., that he has been able to sign on to in different places. So, for a couple minutes, franchising, one of my favorite areas. I'm showing you the Napa because there's so much potential for the Napa. The Napa could actually be seen in the future of a Broadway type franchise, where Broadway productions are brought there, and as well as performances, etc. So what is the main thing I want to end with? Carnival. This thing, Carnival and culture. Well, it has been exhibiting franchise-like behavior for decades. And before Carnival was even considered as something modified, Dr. Sharon Legault looked at the economic viability of IP and said, you know, we are looking at the right track. And if I was to focus on something here, business format franchising, where the owner of the business licenses to another franchisee the right to use the business model. So this is where IP is wrapping into one here. Your brand, your know-how, your different ideas now in the form of a franchise. Juxtaposing that onto Carnival, looking at something like Carnival, the advantages of this global connection throughout the world, a franchising and licensing arrangement. Additional revenue stream. Think about Munich and all these years. I was in South Africa. They wanted every part of our Carnival there and speaking to multiple people. Since we think beyond Trinidad and Tobago, looking at these advantages, making available business concepts, and then royalties coming back to grow demands. So these are some challenges that Sharon looked at. Technical expertise. Issue trademark protection. Well, you have to protect the brand. It's about time you look at protecting Soca Monarch, Chutney Soca Monarch. These will be discussed later on. Panorama, Dimanche Grand, our things and bringing our unique branding. In fact, the Tobago Festivals Commission has just protected all of their festivals with the Intellectual Property Office, and that will be rolled out soon. So with Carnival, when you look at the professionalization of it, you're looking at, just look at Rio, where they've professionalized it by the Independent League of Samba schools, and they're doing the merchandising, they're naming rights, there are arena rights. In fact, the biggest ads are premiered at the day of the Rio, just like Super Bowl that Mr. Mohammed and I so passionately follow, right? Where the biggest ads pay for that time, ads come out of the stand literally at you when you look at the Rio Carnival. Here's Globaliza's trademark, which became the global brand for Carnival. So professionalizing using stadia, you know, not just the Soca Dome, the other stadia to really ring fence IP is where the IP and the Carnival could be going. Organizing obligations, licensing, different corporate sponsorships. This is the snapshot from Daniel's look at the construction of the Rio Carnival. And one of the most important tools is the Madrid Protocol. 126 countries of brand potential online through the IP office. And guess who was the first to use this? The first to use this was Derek Lewis's Carnicon. Here it is. The first ever local Madrid application for Europe, North America, taking the Global Carnival Convention to the world, looking at areas of licensing, merchandising, possibilities of franchising is there, as I've spoke about here, where this event will now be globalized, fenced and exploited throughout the world. There it is for everybody to see. The first ever filing through the Madrid Protocol made history last year. And what is this? It's keeping in with our tourism, Trinidad's thrust, our economic thrust, to take our culture out there, bring in foreign direct investment, as I said, contributing to the orange economy. So to end, go back to my team for the last 15 minutes of today's session. I just wanted to say the support services for the tools, the IP tools exist. There's the WIPO Mediation Center where you can actually enter into agreements to help you proactively to develop contracts. It's all online via the IP office. And there's mediation that can be done, domain name protection here. And it's the cheapest fees in the Western Hemisphere. You could see the fees. So our creators and SMEs can use these services to assist them. And others on the IPO's website includes online filing, online IP diagnostics. It gives you the health of your business, etc. And everything is on the website. So as I end, to my distinguished colleagues, points to remember: exploit your IP, ring fence it, list it. Have a good IP lawyer or a knowledgeable IP consultant. I see one on the screen there, Mr. Mohammed, who has experience, guide you along these ways. Maximize your IPRs by creating and signing agreements. Explore further the cultural opportunities. It's there. Use it, ring fence it, protect it. The tools are there to use. Thank you very much. Back over to you.
Thanks for this wonderful presentation, Mr. Asgarali. I think two very important things were highlighted in your piece, which is number one, non-traditional marks play a factor in our creative sectors. As we commonly know, trademarks are just plain old brand or logo. But I think given presentation, non-traditional marks such as songs, smell, those kinds of things, in our carnival sector per se, plays a lot of importance. And I think given that the Trinidad and Tobago IP office over the years has made the provision for the registration of non-traditional marks, that's very delightful and wonderful to know for those who may have a need for that protection. Secondly, I think something that people don't look at is the motivational aspect of creators. As you have seen in that, as brought up the steel pan, we don't have a lot of pan tuners anymore. We don't have a lot of people who are into the crafts because for the financial benefits are not there. Most of the time they do it for the joy of the culture, the joy of the craft. However, one thing that is not only a great initiative by the IAPO, but by one of our co-hosts, which is Carnicon, is a way to get that out there to international scale. And what I would do like to just further on the IP perspective is hand over to Mr. Kavish Seetahal, who's the Deputy Controller of the Trinidad and Tobago Intellectual Property Office, and Mr. Richard Atching, who's the Manager of Technical Examination, where they can go into detail into how someone who has a need for protection can get that, whether it be at the IP office or elsewhere. So I'd like to hand over to those two distinguished guests. Thank you.
All right. Thank you very much, Khalil. And welcome again to our guest viewing. We're going to get into this really quickly. Right. So what we're getting into is the types of protections. And just to answer the first question, why bother to get it in the first place? We really recommend that you take a long, hard think about why are you seeking IP rights. You don't need IP rights to do business, to have your business model, to run your carnival band. However, I tell people that depends on what is your appetite for regret. Can you live with somebody else profiting from your creations? If you can't tolerate that, then you need to keep on listening. So as we got into some of the descriptions of what some of these things are. Quick overview, copyright and related rights are what we call automatic rights. They come up as you create them. The other side, industrial property, patents and trademarks, which we'll get into a bit, are territorial rights. So that means you're gonna have to file for them. That means you're gonna have to move with some speed in some cases. I'll give you an example. When we talk about patents, when we talk about novelty, that means, is it brand new in the whole wide world? Has it been revealed to the public in its working form more than a year before it was filed? That tells you the window is narrow. I have some illustrations there. You might recognize that shoe heel, that special shoe heel. That's Michael Jackson's patent for the shoe that he used in remember that video, Smooth Criminal, when they did that one scene where all the dancers lean forward. That's not CGI, that's a special shoe. And Michael was a very shrewd businessman, in case you didn't know. And he filed a patent for it because he wanted to be able to use it. Perhaps, again, we don't know. You need to move fast. You need to ask, who are your business partners? Everybody knows about these, the tall boys or the air dancers. And everybody acknowledges they were invented by Peter Minshall. However, the patents were filed by his associates who helped him develop it, Doran Gazette and Aria Dranger. So the patents are in their names. Peter Minshall's name is not on it. You need to ask those questions and move with some speed when you're thinking about that. And you have to ask, is it going to form a one-off for a scene in a video, or is there a business model? Should I bother? Because it has to be non-obvious and has to be industrially applicable. And I can tell you the air dancers were licensed to many people for the life of its 20-year duration. These patents can last up to 20 years. And that patent actually only expired 2019. So what that means, though, is that the technology is free for use now because the patents have expired. That's something to consider as well, that those rights are going to expire sometime. Designs, what are the shapes of the things that you're creating? Are they new? Same rules, not more than a year old. As purely aesthetic, are you going to use it in the future? Should you bother? Those are important questions. Commercial things like the chubby bottle, that ran for its entire duration of 15 years. When you create something in the arts, is it going to be valid more than 2 years from now? Should I bother? Can I afford not to protect it? You have to do a lot of thinking as if you're going to get into this. And I'm going to segue into my colleague, Kavish, who's going to deal with trademarks and copyright to an extent. Kavish?
Thank you, Mr. Ching. Beautiful thing about copyright is that it's an automatic right. So there's no registration process in Trinidad and Tobago. There are registration processes in other countries, but it is an automatic right. So once you express it, it's protected automatically. And that's a great thing. There are lots of other forms of IP that you would require protection for, like trademarks. It's a great thing to register your trademark. And you want to think about having strong marks. You want to think about things that are arbitrary, things that are fanciful, the made up words like Google, things that have no reference, like Apple for computers, those are the stronger marks throughout the world. And those are the most valuable assets in the world, trademarks. So when it comes to trademark, you apply for it, register it, renew it, it's renewable indefinitely, and it is a powerful asset towards everything your organization can do. We have a host of online services, and to end, I know I'll be very short. To end, I will talk about our international treaties. There are a number of international treaties that we are a party to, and Tobago is a party to, that you can access filing different countries around the world. So that is something that you can benefit from. It includes the Madrid Protocol, as our controller said. It includes things like the PC patents. It's going to include Hague for industrial designs coming soon, and Lisbon for geographical indications. These are going to be tools that your organization, whether you're SME or a large corporation, you can use to foster not just in Trinidad and Tobago, but throughout the world. Contact us at the TTIPO, and we will be of assistance to you. So thank you very much. And Khalil, back over to you.
That's the stuff that is the IPO, yeah. Because it's one thing to have a need, but to recognize how to get that need fulfilled. What I would like to do now is over to our host, Hans, who would take us over to our second segment. Thanks again.
All right. All right. Thank you very much, Khalil. So much information in that short session, our first session for today. Remember, we have 3 more sessions coming up throughout the day. We want to say thank you again to Dr. Andres Guadamuz, Mr. Regan Asgarali, Kavish, and Richard also for being part of it and sharing the information. It's so good to know that so much resources are available to us when it comes to intellectual property and how we can monetize and basically earn, protect, identify, and really value our creative assets. Y'all can let us know what you all think in the comments. We appreciate each and every single comment on what is being said today and the information. And closer to the end, we'll actually have more of your questions and answers answered. Due to time, we are unable to do question and answer for that particular segment. However, don't worry, the questions will be answered throughout the day, all right? Just a quick reminder, we want to say thank you to our partners, Trinidad and Tobago Intellectual Property Office, Modcom, Quantum Business Solutions, and Carnicon for all making this available. I mean, it really wasn't expensive. All are free to be part of this enlightening experience. So we say thank you again for being part of Ideas Empowered. This is truly a masterclass